Hi there, thanks for joining again, our latest in a series of consultations that we're doing on the Monaco Solicitors website and YouTube channel. With me right now is my potential client and new inquiry, also called Alex. Hi Alex, how are you doing?
Hi, Alex. Yeah, very well, thanks.
Great, all right, thanks very much for agreeing to sort of come on the show here, as it were. As I've explained, we're obviously changing your name and the details of your case and your voice and everything like that to keep it anonymized, so we can just talk freely. Other than that, about what's happened to you. So, if I can just summarize your case, and then you can tell me in your own words what happened.
Yeah,
But
absolutely.
so I've got a summary here that you've written in. So correct me if I'm wrong, but you were working for a company as a manager, and you were dismissed for gross misconduct after making some errors. And
Correct. Yeah.
that decision was influenced by the fact they thought that you'd intentionally tried to cover up your errors. Now,
Yeah.
you thought, well, you didn't, and you thought you'd managed to prove that. Anyway,
Yeah.
after 10 years of service, you were dismissed on the spot, and you also have a number of extenuating circumstances regarding your personal life that you've had, members of your family been ill, and you've also injured yourself, and
Yeah.
this
Correct.
was,
Yeah.
this was sort of contributing to why the mistakes happened in the first place, and
Yep.
they've delayed. Right, so you're appealing this internally, and that process has been delayed and dragged out for various reasons. You've put in a data subject access request, which has been denied, apparently, and now you're looking for advice from specific employment lawyers, and because you may need to take this to tribunal. So if I can just hand over to you now, and you can just fill in any of the gaps there that I've missed out, and tell me, what happened in your own words, if there's anything extra that you need to add, especially what happened regarding the mistakes that were made. What happened there?
Yeah. Of course. Yeah. So that does sum it up quite well. All sort of all genuine errors. As you say, as I wrote, there were sort of I mentioned the extenuating circumstances because I had been there 10 years. I don't have a record of making errors, so the only thing I could sort of put them down to was the sort of the extenuating circumstances over the sort of the couple of weeks when they occurred. Um, so the reason sort of they found gross misconduct was essentially there was an error I made. So I reported it on Skype, and the comment back was, okay, I'll have to sort of log this in the error log. And I responded, fine, do what you have to do, which was the main basis of them claiming that I was trying to entice the person on the other end of Skype to essentially bury it and, not report it, which wasn't the case. And I feel is a big jump to make. Um, and
Yeah.
then, so yeah, that was basically
Right.
essentially what it was sort of
Okay.
based on.
Right. Okay. So then, to summarize, effectively, you made some errors which would have cost the company money potentially,
Yeah,
and
absolutely. Yeah.
you hold your hands up to that. But the reason they're saying that you tried to cover it up is because you were having a Skype call with a colleague, and the colleague
Yeah,
said that,
absolutely. Yeah.
right, and the colleague said they would have to log this,
Yeah.
and your response was, well, you've got to do what you've got to
Yeah,
do.
the exact phrase was fine, do what you have to do.
Right. So
Which I admit may have been a bit short with the person, but I don't think it can be seen as enticing them to hide it personally.
yeah, I see. So
And then there was then a further error sort of a few days later, unfortunately.
right, okay, Alex. So just to summarize, then a second error occurred, um, some short time later, perhaps a week or so,
It was 2 days
a
later,
couple
I
of
think it
days
was.
later, right?
Yeah.
And the problem with that one is that you didn't report that one for 25
So
minutes.
yeah, absolutely.
So that 25-minute delay, that you didn't report that one for 25 minutes, and therefore they're saying that that was a cover up. But you
Yeah.
actually did report it yourself, that one?
No, that one. So my manager phoned me, and then
Right.
I sort of told him on the phone call, as it were,
But you
which
were
again doesn't look good at all. But it was a
right.
genuine. Just it slipped my mind.
So
There was a lot on that day.
so he phoned you because he noticed the error,
Yeah,
and then
absolutely. Yeah,
you said, yeah, that's right, and then
yeah.
he's like, okay, this is
So
strange.
then
You
obviously then
knew
they had
about it.
to.
Why didn't
Well,
you?
then they had. Yeah.
Right.
So then they had to log it again, and then obviously sort of
Okay.
the conglomeration of errors, and then yeah,
I
as
see.
as I say, they've
So
made the decision that it was intentional.
right, yeah, of course. Okay, and then you put in a so you were dismissed on the spot. So were you paid any notice pay?
No, absolutely nothing.
Right,
I
and
was just escorted out, basically.
so you should have your notice pay, which is going to be about 9 weeks' notice under statutory notice. I don't know what you had in your contract.
Well, if it's gross misconduct, it is just in the contract. It is,
What
firing on the spot, as it were, and
what's your normal
you know.
contractual notice period?
So I was on 3 months.
3 months notice.
Yeah,
Right. So there is definitely an argument there about that.
yeah. I
And
feel
you've got a data subject access request in, which you say that they rejected.
but they came back and it sort of on the grounds, but because it was gross misconduct, they couldn't share that data with me, essentially.
Yeah. Well, you can go back with a less wide subject access request.
Yeah, absolutely.
And
Yeah.
then obviously if they still refuse that, you can go to the commissioner about that, the data
Okay.
commissioner. So you can escalate that, and there's details about that on our website.
Okay. Excellent. Yeah.
You've got to be aware of a 3 month limitation period. So you've got 3 months from the date of your dismissal minus 1 day to put in a claim at the employment tribunal, or to go to ACAS to do an ACAS certificate. So you
Okay.
should go and do an ACAS certificate before the 3 months is up.
Yeah. Okay.
All right. So
Sorry,
let's
is that
say
3 months from the dismissal or 3 months
from the
the?
dismissal,
Okay.
yeah,
Yep.
minus 1 day. So
Minus
don't
one
leave
day.
it to the
Okay.
last minute. Right. So to get more info on the ACAS certificate, go onto our website and search for
Yep.
ACAS, and find out. There's a link in there to do an ACAS certificate. That will extend it for another month, depending.
Okay.
What happens. So there could be another month of negotiations between the parties, and then they will issue an ACAS certificate after that to confirm that you have another month to issue a tribunal claim.
Okay.
So, in other words, just put your ACAS certificate in to extend your deadline.
Okay. So that
Now,
doesn't necessarily mean that I do want to go to tribunal or anything. It is just
no,
an extension. Okay.
yeah, people do extend the sort of limitation period to negotiate. Now,
Okay. Excellent. Yeah.
these
Perfect.
sorts
Yeah.
of gross misconduct type situations are very difficult to negotiate unless
Yeah.
you do actually sue the company. So you may have to put in a tribunal claim, and you
Yeah.
might
Okay.
have
Yeah.
to do that with a lawyer. And frankly, if you don't do that with a lawyer, it's unlikely that the company is going to settle with you, especially
Absolutely. No,
if
of
they
course.
have a
Yeah.
lawyer, because by and large, where there's been some sort of misconduct or some sort of negligence or some kind of mistake, then a company does have often has a fairly wide discretion of what to do, so they
Absolutely.
can
Yeah.
dismiss. So unless they really think you're going to go to tribunal all the way, and that's why you'd need a lawyer really to send that signal, because then you're drafting your tribunal claim in a proper way that looks like it's been done by a lawyer, it's got a lawyer's name on it. They think,
Absolutely.
right,
Yeah.
actually, Alex might want to go all the way to court here.
Absolutely. Well,
Unless you
that's
do
why
that, right, it's unlikely because they will feel that they're perfectly justified.
Yeah,
So
absolutely. Yeah.
then,
Well, that is why I sort of got in touch with you to get some more sort of,
right,
advice that I can actually use rather than, because obviously, as I
exactly,
say, I've sort of gone to lawyers, but I can't actually use either of them because obviously one's ex-colleague's wife who I can't get involved, and the
right,
other, the company my brother works for actually deals quite closely with the company I was at.
yeah.
So obviously I can't use their legal department,
No, fair enough.
officially.
I mean, what we might do here in a case like this is to charge something like £1,000 plus VAT, maybe, to do the claim form itself, and
Okay.
then do a percentage of anything, that a settlement amount that would come off the back of that as well, perhaps
Okay.
20% off that, because, as I say, these are very difficult cases, right? This is
Yeah.
not, it's not an easy case. So all they'd have to show is that, well, there's two different tests. So in terms of the gross misconduct, they'd have to effectively show it was kind of gross negligence, if you like, that you breached your
Yeah.
contract. Now, there's a slight danger here. If you claim for that in the tribunal, they could counterclaim and say that that you breached your contract and it caused them loss. So if they can show how much loss that they suffered, financial loss, they could counterclaim for up to £25,000 against you
Okay.
in the employment tribunal. So that is a bit of a difficult scenario that you've got there.
Yeah.
In terms of whether they could dismiss you just in terms of unfair dismissal, it's much more likely that they'd be able to get home on that. In other words, they'd be able to show that that it was not unfair dismissal. So that they were within their rights to dismiss you, because it's quite a wide discretion that they have.
Yeah.
The
Absolutely. Yeah, of
test
course.
is
Yeah.
the test is that they're within the reasonable range of responses. So a tribunal won't look at it and replace their decision with the decision of the tribunal and say what they should have done. What the tribunal
Okay.
say was, well, this was the range of responses open to them, was dismissal in the range. Even if it was at the extreme end of the range, it was still within that range.
Yeah.
So
Absolutely. Yeah. I understand that.
even
Yeah.
if the judge wouldn't have done it, they would say, well, the employer has the discretion to do that. So they would potentially have discretion to dismiss you. But whether they could do that without paying you notice, I feel that you could write them with a without prejudice letter. Once you've done your ACAS certificate, write a without prejudice letter, say that you are going to go to tribunal and you do want your 3 months notice as
Mhm.
as a settlement, as a way to get an early settlement. So to save everyone all of the time and effort and money to go to court. And if you really pushed it all the way to the court, to the door of the court, you probably find that on the day before or thereabouts, they probably give up, because
That would.
they
Yeah.
wouldn't want everyone in the courtroom. They wouldn't want the managers and everyone else to give evidence. It's too disruptive.
Yeah.
But
That was
you
what the other. Yeah. That was the advice I had basically.
right.
Was
So
yeah.
it's
Very
difficult for
similar.
you though. But how do you push that case all the way to the door of the
Yeah.
court? As you're not a lawyer. So the fact is, you'd have to have a lot of determination to do that. And
Yeah.
you can research that stuff on our website, how to do that, and online generally. And there's a great book you can buy, to Employment Tribunal Tactics and Precedents by Naomi Cunningham. Nothing to do with us. We
Okay.
also
Yeah.
have a book about how to negotiate settlement agreements, which is decent, which is called Resignation Revolution, which you
Okay.
should
Brilliant. Yeah.
also read. But you're going to have to start reading books, basically. Is what I'm
That's quite
saying.
right. Yeah.
So it's going to be, getting almost like a lawyer hat on and becoming a trainee lawyer to do that. Obviously,
Well.
you
Yeah.
can pay lawyers to do it, but because you're not working, I imagine that's not on your top of your list to go on a spending spree for lawyers.
Absolutely.
So really, a good compromise here would be to get your notice pay, I feel, and you've got a duty
That's
to.
all I'm really after. If
Yeah.
I'm being completely honest, that's what I've said the whole way along. I don't
Yeah.
want to punish them, or I don't want,
Right. Have you said this to them?
No, I was going to
Okay.
ask you that whether you would advise to or not, basically.
Yeah, I think it's a good idea. Write them a letter without prejudice and say, look, you just want, you just want your notice pay, but you're happy to go to court. If you do go to court, you'll obviously be claiming for all your future loss as well. I mean,
Okay. Yeah.
I don't know if you've got another job.
Not
already.
yet. No. Well, so obviously, sort of reference as well is quite a big thing for me.
Yeah, yeah,
So it is just essentially just a reference and
right.
notice period really is what I'm after.
So you could get a standard reference, which is just dates of employment and job title,
Yeah.
probably the safest bet. And that way you could get that agreed. If they do agree to enter a settlement agreement with you, you could get that written into the settlement agreement. And
Okay.
if they get a request for a more detailed reference, it could say in the settlement agreement that they should just tell that other prospective employer that they only give standard references due to their policy, for example.
Okay.
So that protects you in terms of if someone else asks, well, we want more information, and
Yeah.
then it stops them from going into greater detail about it. So
Okay.
they could only give a standard reference, basically. And that's the sort of thing that could be written into a settlement agreement document.
Okay. Yeah.
If you do go down that route without us, obviously do bring in that document back to us and we could sign it off for you. because there's always signed off by your lawyer to make it legally binding.
Yeah, of course,
And,
yeah.
the company pay for that, so it wouldn't cost you anything. Or if you wanted us, for example, to write the without prejudice letter for you, or to do the tribunal proceedings, again, you could talk to us about that once you've had a little think about it.
Okay, yeah.
I mean, you've got a couple of options there. I don't know how you
Yeah,
feel about
absolutely.
that.
Well, obviously, yeah, no, it's a great advice about the ACAS certificate,
Yeah,
because obviously I was warned that they might just be sort of, because they've taken so long with the appeal, that they might be trying to sort of run time down a bit, or,
yeah,
wait for me to crack, as it were. So obviously I think that
yeah,
will show them that, I'm not going anywhere, I suppose.
absolutely.
And then, yeah, I've been so tempted to sort of, ring my old manager essentially and say, all I want is my notice, but I just didn't know how to go about it, and I didn't want to obviously damage my position by doing anything, because this is all a bit alien to me, I've got to admit.
Yeah. So I wouldn't necessarily just ring your old manager and just ask for what you want in that sense. I would write a
Okay,
without
yeah.
prejudice letter.
Okay,
So go on our website, look up without prejudice letters, and there's a
yeah.
couple of articles about how to write them. And you
Okay,
literally
brilliant.
set out all your years of, dedicated, loyal service, everything you've done for the company. You set
Yeah,
out, how you see you've been badly treated and what you might end up doing, which is, in other words, going to tribunal. It's very important to set that out
yeah,
so they
absolutely, yeah.
so they understand what's in it for them. Don't just ask them for the money. They need to
Yeah.
understand what's in it for them.
Oh,
So
absolutely, yeah.
you've got to be very clear that you're going to go to tribunal. You've done the ACAS certificate, but at the same time you do want to settle amicably and quickly. So what you think's fair is to just give you your notice, pay, and a standard reference, and a settlement agreement with a £500 legal advice fee in there as well for you to get advice. And that way you're going to they're saving themselves paying any financial loss, because you're struggling to get another job and it could take you a year, and you'd be more than happy to uh, ask a tribunal judge to award you a year's salary compensation. So
Yeah.
make it clear to them that that's the risk. So that's what you can do there, and then you can assess at that point. If they do say no, then you can come back and go for the tribunal claim and issue the claim.
Yeah, absolutely. No, that sounds perfect, really.
All right, perfect. Well, get in touch. Yeah, let us know how that goes. And if you want us to do any of that for you, we're more than happy to. And
Absolutely. Well, I'll look into the without prejudice letter.
yeah,
See how complicated it is, and I might get back to you. Yeah.
yeah, exactly. All right, great stuff, Alex. Well, thanks for calling in. Really nice to speak to you. Good luck with it all.
Brilliant. Well, yeah, you too. Thank you so much.
Cheers. No problem.
Cheers. Bye.
Bye. Right, that's it for now. Thanks for tuning in to another Monaco Solicitors consultation. Don't forget to like this video and subscribe to our YouTube channel. Leave a comment as well below in the below the YouTube description. Or if you're watching us on our website, have a look at some of our other videos. And thanks very much for watching.